I now recognize the gentleman from New York, our nation's really our financial center, our greatest financial center, obviously very concerned about cyber. Mr. Goldman, for 5 minutes questioning.
Yes, Mr. Chairman, thank you very much, and I agree. Those in New York City and around the country are very concerned about cyber. We must be operating in la-la land here, having a hearing on preparing the pipeline, examining the state of America's cyber workforce, where we have 3 academics who have been brought in by the majority to talk about the education and training that we need for more cybersecurity employees, while at the same time, the president and his unelected billionaire master are gutting every single executive branch agency. What's the point of having a pipeline with education if you're taking away all of the jobs? If you're sending unvetted teenagers with no security clearance into our various executive branch agencies, allowing them to hack and slash into the government payment systems, the government portals, the government databases, without any regard to cybersecurity, putting them on private servers. And quite obviously, to anyone, whether you're an expert on cybersecurity or not, you understand how that jeopardizes the security of every single American's personal identification information. It provides an opportunity for China, who just executed the largest cybersecurity breach of the federal government ever a couple months ago, to have access to private servers that are so clearly easier to hack into, and we have no idea whether these people have security clearances, whether they got their security clearances because Donald Trump passed an executive order saying that he can just bestow security clearances on anyone for 6 months. And so maybe he did that. I mean, maybe it's the same thing as Kash Patel saying that Donald Trump thought about declassifying classified information, and therefore it's declassified. And that's going to be potentially the new FBI director, who is going to oversee counterintelligence and cybersecurity for the FBI. This is a guy who supports the purges at the DOJ and the FBI, who promised the purges at the FBI and DOJ, who lied right, left, and center during his hearing, who has circumvented normal protocol and practices when he was with the National Security Council, when he was with the House Intelligence Committee, when he was with the Department of Defense, who every single former Trump administration official has said is wholly unqualified and dangerous to be in that job. And you want to talk about cybersecurity and recruiting more people? How about we not have heads of executive branch agencies who are jeopardizing our own cybersecurity, who are jeopardizing our own security? How about having some degree of protection over our personal identification information? Who on earth would ever want to join the federal government now? If you are associated with a prosecution that the President of the United States does not like, you will be fired. You will be fired. What law enforcement system in a democracy allows or supports the President of the United States to order the firing of nonpartisan, highly trained law enforcement officers simply because they worked on a case that the president didn't like. That is banana republic shit. And that does not belong in this country. And what else doesn't belong in this Congress is this stupid hearing, where we're talking about educating a workforce where there's no demand for that workforce anymore because Elon Musk is destroying that workforce. It's like we're in La La Land, Mr. Chairman. You're pretending as if reality is not happening down the street, and we need more education for cybersecurity. This is a joke. And I hope, at least, Mr. Chairman, if you're gonna have hearings on cybersecurity—
Gentleman's time has
that
expired.
you will at
I
least—
now recognize Mr. Ogles for 5 minutes of questioning.
I want to thank you, Mr. Chairman, and thank you.
Mayor of New York. Gentleman from New York is recognized.
Thank you, Mr. Chairman. Of the 8 hearings on this topic, I do give you credit. This is only the 3rd one with these same witnesses. This one, though, introduces a new wrinkle: censorship by foreign countries, of course, which Congress has no jurisdiction over. So I do give you some credit, because at least the first 2 with them had something to do with our jurisdiction.
Gentleman yield?
Not yet.
Okay.
Now, let's look at what has happened over the past 3 weeks. Donald Trump pardoned more than 1,500 criminals from January 6th, including hundreds who were convicted of assaulting police officers. So much for backing the blue. He tried to freeze all federal funding: SNAP benefits, Medicare, Medicaid, Social Security, tax refund checks, you name it. He illegally fired senior officials and inspectors general, and even the director of the Office of Government Ethics, because they might, God forbid, provide accountability to the convicted felon in the White House. And the president has given an unelected billionaire total access to the inner workings of every executive branch agency. And he is freely terminating government contracts and government officials. Now, whether you agree or not with whatever Donald Trump and Elon Musk are doing, it is a breathtaking and unprecedented usurpation of government power. And instead of Congress actually using its oversight authority to provide a check and balance on this government takeover, the Republican majority is once again here talking about Hunter Biden's laptop, the Twitter files from many years ago, and now a new one: censorship in Europe. Now, when asked about what guardrails there may be on Elon Musk's infiltration of our federal government this past weekend, the chairman said, and I quote, "The guardrails are all you all in the press who are talking about it every day," end quote. The press? The press? What about Congress, Mr. Chairman? Our Constitution places responsibility for oversight and accountability on Congress, not the press. It is almost as if my colleagues on the other side of the aisle wake up in the morning and think, how can I undermine my own power? Let's be very clear. Nobody has any idea what Elon Musk is doing, including the president, including my friend from Texas, who has no idea whether Elon Musk has found fraud or not. And I find it shocking that my Republican colleagues are willing to simply take Elon's word for it. Just yesterday, Mr. Musk admitted that at least some of what he says is incorrect. So even Elon Musk does not take his own word for it. Now, how about this committee investigate Elon Musk's rampant conflict of interest, Mr. Chairman? He has 6 companies that have at least $13 billion of government contracts. And here he is making decisions about what government contracts should be canceled. And I want to introduce, by unanimous consent, an article in the New York Times from yesterday that talks about the 32 ongoing investigations into Elon Musk and his companies. This article outlines how Trump and Musk have fired officials in 11 federal agencies that are leading investigations or enforcement matters or lawsuits pending against Elon Musk. Now, all the investigations have stalled. Lucky Mr. Musk. Can't be the conflict of interest.
Not objection. So enter.
The Consumer Financial Protection Bureau has received hundreds of complaints against Tesla Last week, after Elon Musk gutted that agency that protects everyday Americans against corporate greed, Mr. Musk tweeted, CFPB, RIP. Now, these are clear conflicts of interest, and it is clearly within the jurisdiction of this committee to investigate, with our oversight power, the conflicts of interest. And you know what the White House's response is? Let the guy with the conflicts decide if he has conflicts. Just yesterday, Mr. Musk announced that he canceled 89 government contracts worth $881 million in the Department of Education. That's money Congress appropriated. We have the power of the purse. Maybe it's wasteful, maybe it's not. I have no idea, you have no idea, but it's a blatant violation of the law and the Constitution. And apparently my Republican colleagues are so weak and afraid of Donald Trump and Elon Musk that they're willing to undermine their own constitutional authority just to please them. You're giving away your own power in fealty to Donald Trump. So, Mr. Chairman, I ask that for our next hearing, we actually do some oversight and accountability of what this administration is doing right now, not what the Biden administration did years ago. And I yield back.
Gentleman yields back. I would just ask Mr. Schellenberger, if European law results in the censorship of Americans, is that something that the Judiciary Committee should be concerned about?
Yeah, absolutely. And you shared that information this morning on X, the post about the judicial ruling in Europe, which says that they do think they have the right to do that. And we keep seeing this similarly in Australia, where you see these authorities who think that they should be able to censor the entire global internet of disfavored information. So it's very disturbing, and like I said, it really makes you question our alliance with Europe.
Mr. Chairman, I have a unanimous consent motion.
Gentleman's recognized.
I ask to introduce by unanimous consent a letter from 7 members of Congress, including myself, to Inspector General Michael Horowitz of the DOJ, asking him to investigate egregious conflicts of interest of Acting Deputy Attorney General Emile Beauvais and Acting United States Attorney for the District of Columbia, Ed Martin.
You're asking to enter into a record a letter you sent to who?
To the Department of Justice Inspector General Michael Horowitz, one of the very few who was not fired.
Without objection. All right, that's fine.
And I will just say, as a representative of New York City, and a former prosecutor in New York, I resent and object to the insinuation from my colleagues on the other side of the aisle that a jury of 12 New Yorkers cannot issue a fair and impartial verdict. And I'm sure that if I said a jury in Wisconsin could not issue a fair and impartial verdict because a defendant was a Democrat, you would object too. And you should, because it's baseless. All of these accusations about lawfare that we hear over and over and over again have no evidence to support it. You say the judge in that trial was politically motivated. Why? You say the judge was motivated? Is it because his daughter works for a digital fundraising firm, that all of a sudden that's politically motivated? That the jury, you can't get a fair trial now in New York? Give me a break. Mr. Terwilliger, did you read the search warrant for Mar-a-Lago?
I might have read parts of it. I don't know that I read the whole thing.
Mm-hmm. And you spent 15 years in the Justice Department as a prosecutor. I spent 10. I left 7 years ago. I hear you say that in the last 10 or 15 years, it's been completely politicized. I have no idea what you're talking about. When I was there, I didn't, just like you, I had no idea the political leanings of my colleagues, of the FBI agents I worked with. So I appreciate your accusations. Maybe after my 5 minutes, since I don't have time, I'd love to hear why you think that all of a sudden 15 years ago, the Department of Justice changed. But if you read that search warrant and you were a Deputy Attorney General and you were asked to review that, would you say that that did not have probable cause?
I would assume, without my having read it, that a magistrate signed it and determined that there was probable cause. But I don't think that's
obvious. I'm
here
asking you.
That's not either here or there.
Well, it is. See, this is why it is, Mr. Terwilliger, because this is the accusations and allegations from my colleagues on the other side of the aisle, that the search of Mar-a-Lago for classified documents after Donald Trump repeatedly and persistently obstructed justice, obstructed an investigation, held on to classified documents, lied about it, told his lawyer to lie about it, that all of a sudden that search warrant is unprecedented and must be lawfare and politically motivated. Wrong. That was, I don't have a question for you right now, Mr. Terwilliger, but I will, because I want to know, and I want to focus on the here and now. I want to focus on the last 6 weeks. You were a Deputy Attorney General, correct, Mr. Terwilliger?
Yes.
And it was under the George H.W. Bush administration. You spent 15 years. You may be Republican now, or were then. I'm sure it had no impact on the job you did. You're here as a Republican called witness. Let me ask you something. As Deputy Attorney General, did you ever appear yourself in court because no one underneath you would actually appear in court to represent the Department of Justice?
I don't recall having to do that, but I would have if I had to.
Okay, I don't know what that means, but you never did that. Have you ever heard of any Deputy Attorney General doing that? Before the last 3 weeks?
I actually do have some recollection of that, but it's not sufficiently clear for me to be able to give you.
Fair enough. and
Probably
maybe
not.
you're right. It was quite remarkable that the acting Deputy Attorney General, Emile Beauvais, had to appear in the Southern District of New York himself as the Deputy Attorney General because 7 prosecutors underneath him resigned rather than defend a plea agreement that he put in writing was not based on the facts, evidence, or the law. Mr. Terwilliger, I'm sure you'll agree with me that the only job that the Department of Justice has is to follow the facts, evidence, and the law. Is that right?
I would agree with that, but I'd also tell,
Okay, so
I would also
I gotta
say,
cut off,
sir,
Mr.
that
Terwilliger, I didn't ask you
assistant
another
U.S.
question.
attorneys have a duty
The other
to follow
problem we
their
have
orders.
here is the U.S. Attorney in Washington, D.C. And unfortunately, I don't have enough time to get into him, but to actually say that I am the president's lawyer, I hope you recognize, Mr. Terwilliger, as someone who cares about the Department of Justice, that undermines the entire law enforcement system more than anything that anyone else prior to January of this year has ever done. And I yield back.
Thank you, gentleman from New York. I'd recognize the ranking member.
Yes, I have a couple unanimous consent requests. First, I would ask unanimous consent to enter into the record an excerpt from the committee's transcripted interview with Stephen D'Antonio, former Assistant Director of FBI Washington Field Office, on June 7, 2023, in which he explained that the FBI executed a search warrant for classified material at Mar-a-Lago because there was probable cause to believe that Donald Trump did not fully comply with a subpoena to turn over classified documents.
Without objection.
Okay. I also would ask unanimous consent to enter into the record another excerpt from the transcribed interview with Stephen D'Antonio, in which Mr. D'Antonio explained that he would describe the search on Mar-a-Lago not as a raid, but as a lawful search pursuant to warrant.
Without objection. I now recognize.
Mr. Chairman, I have a unanimous consent request.
Briefly.
Sorry, I'd like to introduce a New York Times article dated yesterday entitled U.S. Attorney Rebuffed by Justice Department in Push to Escalate Inquiry into Schumer related to Ed Martin, the acting U.S. Attorney in Washington.
Without objection.
And then one more, I have a letter dated February 12th, 2025, signed by me and 6 other former DOJ lawyers to the Inspector General, Michael Horowitz, asking him to investigate acting Deputy Attorney General Beauvais and acting U.S. Attorney.
Without objection.
Thank you.
I will now recognize the gentleman from Texas, Mr. Gill, for 5 minutes.
Next is the gentleman from New York, Mr. Goldman.
Well, I agree with Mr. McDermott. Everybody in this room recognizes there's a right to self-defense, so I hope my colleague from California is permitted by his former colleagues to speak at the hearing on the California bill that is not a bill in this Congress. Mr. McDermott, I want to just clarify something you said. You said earlier on that in Chicago, the gun laws have not worked. I beg to differ. The Everytown gun law rankings that just came out, and I'm happy to introduce this, has Illinois, in terms of its gun law strength, at number 3. California's 1, Massachusetts 2, Illinois 3, my home state of New York 4. The problem with those states is that there is an iron pipeline where guns that are manufactured outside of those states are trafficked into those states. The ATF is the federal government agency that is charged, and I believe, Mr. Jackson, am I right, that the ATF is the only one with technology that can trace guns?
They're definitely the best at it.
Yeah, and so most local law enforcement send the guns to the ATF to trace so that they can figure out where they're coming from. That allows us to enforce federal laws against gun trafficking. Now, I want to raise a different point here because not only was Kash Patel recently confirmed to be the director of the FBI, he has never managed a local bakery, much less an institution of the size of the FBI. But then President Trump named him also to be the acting director of the ATF. Mr. Patel spoke at the inaugural summit of an organization called the Gun Owners of America, which says on its website that they advocate for abolishing the ATF. Mr. Jackson, briefly, can you just summarize what would happen if the ATF were abolished?
I mean, we would lose the ability to federally enforce rogue gun dealers, to focus on disrupting problematic iron pipelines, as you spoke of. There's multiple across the country. To prosecute gun traffickers. It would greatly handicap our background check system and our ability to identify and frankly deny dangerous sales of firearms. And most importantly, it will strip us of the ability to look out for emerging threats. We know that there are things like Glock switches and innovations that are happening every day that are making weapons more deadly.
Ghost guns as well. Now, that's not just a potential problem, that's a real problem because the president has issued an executive order to reevaluate every gun regulation that has been implemented by the Biden administration through Mr. Jackson and the excellent work and part of the Office of Gun Violence Prevention. Now, one of those rules is the engaged in the business of selling guns rule, which is clearly a target of my colleagues on the other side of the aisle. And it's pretty remarkable to me because that rule, which is often referred to as the zero tolerance policy, revokes federal firearm licenses for people who, one, willfully transfer a firearm to a prohibited person, someone who the law says is not allowed to own a gun. 2, fails to run a required background check. 3, falsify records. 4, fail to respond to a tracing request. Or 5, refuse to permit ATF to conduct an inspection in violation of the law. In other words, that regulation is designed solely to enforce the law. And yet, for some reason, that is a purported infringement on our Second Amendment rights. Ms. Mueller, I have a couple quick questions for you. Is there a Second Amendment right for a mentally ill person to own a firearm?
There isn't one that isn't.
Is there a Second Amendment right for, I just have a little time, for someone convicted of or with an outstanding order from domestic violence to own a gun?
Repeat the question, please.
Can someone who has committed domestic violence own a gun? Is there a Second Amendment right?
Gentleman's time has expired. You may
No,
answer the
sir.
question if you can. Thank you.
No, sir.
No, there's not. This is not a Second Amendment
Your
issue
time
that
has
we're
expired,
talking
sir. Thank you. Chair now recognizes the gentleman from Texas, Mr. Nels.
Thank you, Mr. Chairman. And Mr. Kiley, thank you for your questions. You think about California. Well, it's California. You figured that. You know, as an old sheriff in Fort Bend County, Texas, we love the great state of Texas.
This will be the last round until the recess. You're recognized.
Thank you. Thank you very much, Mr. Chairman. Mr. Gingrich, I want to focus on some of your testimony today. You say that a judicial coup d'etat is being implemented by judges of the same political ideology. In another statement, you said that Judge Boasberg has a clear bias against President Trump. Do you know who appointed Judge Boasberg?
I think his first appointment was by George Bush.
Correct. And we've been talking about nationwide injunctions. There's been a lot of discussion about the injunction on the president's birthright citizenship executive order that was enjoined by Judge Kuenhauer. Do you know who appointed Judge Kuenhauer?
No, I don't.
Ronald Reagan. So let's just focus on these two Republican-appointed judges so we can just remove all the allegations of partisan bias.
So we're removing the other nine.
So let's focus first on Judge Boasberg's case, which is the Alien Enemies Act of 1798 law that very specifically applies during wartime or if the country is subject to an invasion. Now, you would agree, I assume, as a former Speaker of the House, that it is Congress's duty to declare war.
I think there's also a provision of that act which does say for invasion, and I think the average American will tell you they feel that we've been invaded by the policies of the Biden
So the average, so are we now supposed to say that your assessment of the average American's view determines whether or not we are under invasion by Venezuela? So that's what we're supposed to do. Now, is it, if not the average American, what your testimony is here today is that Donald Trump, because he was elected president, alone should determine whether or not that law applies without any due process. Is that your testimony?
No, my position is that the Supreme Court should have the opportunity in a nationwide issue to render, but remember.
Okay, so let me reclaim my time. So basically what you're saying then is the problem here is that Judge Boasberg pre-certified a class because, of course, it is the exact same legal question for every single person who was removed to El Salvador. And what really should happen is that every single one of those people should have to file their own lawsuits. And each district then judge should rule on it. Because that's the difference, the opposite of a nationwide injunction, right?
Actually, as I've said several times in the last 3 hours, there can be a provision by which the Supreme Court takes up that injunction.
So which is it?
Do
you oppose nationwide injunctions as a judicial coup d'etat?
No.
Or do you think nationwide injunctions are appropriate in certain circumstances but should have expedited appeal?
I believe that nationwide injunctions by an individual judge is far too much power, and that there could be a procedure.
Let's keep on with Judge Boasberg's case, okay? So he issued, and by the way, he did not issue an order on the underlying issue. He temporarily enjoined the president from whisking off people to another country without due process so that the legal issue could be resolved. Now, you say expedited appeal. That opinion, that case was already appealed to the district court, the Court of Appeals for the district court. They've already ruled. And by 2-1, they kept the temporary injunction in. It was a Republican appointee, Judge Henderson, who was one of the two. So I guess I'm confused as to what the problem is with a temporary nationwide injunction so that the issue can be resolved, and if necessary, ultimately by the Supreme Court. It sounds like you agree with me that that is the appropriate process.
The difference is whether or not you believe, one, that time matters, and
well, this was within a matter of weeks. It's now up before the Supreme Court. That's expedited, and I will say, I wholly agree with you, and to my colleague, Mr. Kiley, I would happily work to expedite appeals for nationwide injunctions. I hope my Republican colleagues would work with us to expedite enforcement of congressional subpoenas. The courts take far too long. I agree with you. But the notion that we do not have due process and that someone should be removed without due process based on false pretenses, which the administration now admits under a petition for habeas corpus, I would add, Mr. Larkin, and that there's no recourse because their mistake is now out of their control. I think even you, Mr. Gingrich, would agree with me that when you mistakenly accuse someone of being a gang member and you deport them, that it is incumbent upon you to fix that mistake. Do you agree?
I agree.
And with
Gentleman from Maryland.
And I yield the gentleman from New York 1 minute and 45 seconds.
Gentleman is recognized.
Thank you to the ranking member. Thank you, Mr. Speaker. I rise today in opposition to this bill, which is simply an attempt by House Republicans to intimidate judges who issue rulings that they simply don't like. My colleagues concede that it is the Supreme Court which determines what the law is. Well, in today's modern age, how do you get to the Supreme Court? You go first through the district court, then through the appeals court, and then up to the Supreme Court. Now, there are many complaints that takes too long. I agree, but we're citing rulings on the other side of the aisle of Supreme Court rulings on these very nationwide injunctions within a few weeks. And even former Speaker Newt Gingrich, the Republican star witness at our committee hearing last week on this topic, conceded that nationwide injunctions are appropriate in some cases. And that's why this bill is not about the substance. It is clear that the House Republicans have completely abdicated their own constitutional duty to be a check and balance on the president. So the only remaining check that is left in our separation of powers is the courts. But it's not enough for my colleagues to hand over all of their own authority to the president. They want to hand over the judiciary branch's authority too. A fundamental principle of our Constitution is that the courts decide what the law is, not Congress and not the president, even if he is elected, which I would note for our friends down at 1600 Pennsylvania Avenue is true for every single president. My colleagues complain about the high number of nationwide injunctions during the first 3 months of this presidency. Well, rather than blame the judges for that, I've got an idea. Stop breaking the law. This is a bad bill that gets us nowhere other than toward autocracy, and I yield back.
We reserve.
Gentleman from Maryland, reserve.
Yes.
You're recognized.
Thank you. I just want to emphasize what my colleague from Puerto Rico said. It would be one thing if it were just numbers. Then, if it were just numbers, we'd be talking about transparency to the American people, and realistically, it would have no impact on whether or not our homeland is safe, because we're not asking the department to gather more information on people. We're not asking them to do anything differently than what they're already doing to keep our homeland safe. This, of course, is not numbers. And the problem not just numbers, the problem is when you're adding in public reporting, there is a benefit to transparency for the American people. I fully agree with that. But there's also a tremendous benefit to the organized gangs who are trying to infiltrate our country. And I appreciate the lesson that Ms. Green was trying to pass on to me, but as somebody who prosecuted organized criminal enterprises for 10 years, I can tell you that this kind of information only helps the enemy. It does not stop them. And it's bad enough that you're misrepresenting what your bill says, but it's even worse than the fact that the information that's being provided will help the enemy and will do nothing to help keep our homeland secure. So I wish that, A, we had an accurate representation from the sponsor of this bill as to what it is, and B, that if it were actually that, we'd be having a very different discussion. And I yield back.
Gentleman yields. Mr. Luttrell, you're recognized.
I do, and I feel like this has come completely off the rails. Dan, I'm going to chat with you. I disagree. I think if countries are well aware and under the microscope and they know that we see them, that puts them in a different posture. Now, my colleague stated it was numbers. I don't understand, if she would have stated numbers in countries of origin, and DHS is the one that's doing the processing, as they have done currently and in the past, this just codifies legislation that says this is something that Congress wants. And it's not Congress, it's not Morgan that's down there pointing people out, saying, hey, look, you're obviously an SIA. It's us assisting DHS in amplifying our ability to defend ourselves. So I guess my question is the problem with, should it be just numbers, or why is it a problem with its numbers, countries of origin, where we're letting the American people like, hey, we are very well aware of the problem set. We are laser focused in on these areas. And I personally think that's a good thing. I yield.
Yeah, well,
Gentleman yield.
I think first of all, I think we have to distinguish between foreign governments and foreign terrorist organizations.
Okay.
Who are often different.
Will you yield? Okay, I forced
your time.
Yeah, I'm sorry, I forced here. Okay,
Reclaim
forgive my speech if I don't say, I mean the terrorist organizations that we are focused on, not specific governments and so on, or if that's included.
Right. Well,
and I know you're going to go granular on me here.
I'm not going to go granular because I think that you have to recognize a foreign terrorist organization is a professional criminal organization. They assume that they are under surveillance. They assume that they are being investigated, that they are being targeted. So by releasing the information that there is actual targeting of them does not give them any information that they don't already know. You're not gonna be able to say, oh, wow, they're looking at us now. We better be more careful. But what they are gonna get is...
That's exactly what will happen.
But they already know that. And what they will then learn is not anything that not any surprise that they're being investigated. They will actually learn how we are investigating and targeting them, which allows for them.
I disagree. They will just know through the publication. I'm sorry.
What we don't want to do is you just reclaim your time. So to members, all the members committee, right and left. I mean, if it's your time, you can reclaim your time.
Yeah,
So if you're reclaiming your time, it's yours.
Okay, no, I just lost my train of thought. Sorry, go ahead.
Well, we're not going to, this isn't a debate.
Well, my frustration is we're talking about a piece of legislation here, and again, it has come off the rails, so now our Democratic colleagues are totally against the Republican colleagues, and now we're in a fist fight in the middle of the committee.
No, we're not. They're making their points and you're making your points. That's what it is. But you have to do it by the rules of the committee.
Trust me, I would never want a fist fight.
Yeah, all right. And I hate to say it, hang on, I reclaim. I just think.
All right, the order. You have a minute and 23 seconds, Mr. Luttrell.
I hate to think that we have gotten lost in the actual legislation that I personally think promotes good information to the American public and Congress. And I understand your perspective, sir, but as a former member of the military that did this for a living, putting them back on their heels and understanding that we're aggressively coming at them makes their tactics, techniques, and procedures fail. And then they have to start completely over, and then we continue to maneuver.
Would the gentleman yield for one comment? We are in agreement on this, that figuring out effective measures to put these organizations on their heels is critical. And that is where the department's energy should be placed, not on disclosing in various forms information that they already have, that they could publish if they thought that were effective counter surveillance and effective investigation, but instead to essentially create busy work that, yes, I'm sure the American people have an interest in this, but I don't think that the American people's interest in this will have an impact on keeping our homeland safer. So I would love to work on other ways of targeting these foreign terrorist organizations so that we can actually put them on their heels. This bill doesn't do that.
Yeah. I yield back, sir. Thank you.
Gentleman yield.
Thank you, Chairman. The silence. I want to talk a little bit more about the silence. I'm going to invite Professor Raskin in on this. Professor, we have alleged that this legislation which would further deport kids with cancer who are American citizens, that would deport and exile American citizens, that would allow the firing of veterans who work at the Department of Justice, that would allow the hiring of January 6th rioters at the Department of Justice. We've alleged that that is cruel and incompetent. My colleagues across the other side have said nothing. We've given them multiple opportunities to defend it. Now, I do my CLE, my continued legal education, but I'm a little rusty. I've been here for 13 years. You're not rusty. In the law, I remember something called like an adoptive admission. So if I say to the other side, what you're doing is cruel, what you're doing is incompetent, and it's just like zip, heads down, kind of like what my kids do when you catch them with their hand in the cookie jar and they don't want to talk about it. What is an adoptive admission? What does it mean that they're being so silent? And what could you conclude in the law that they've been accused of being cruel and incompetent and deporting kids with cancer who are citizens, and they say nothing? What's an adoptive admission?
Well, an adoptive or a constructive admission, as it's sometimes called, means in certain contexts that you can construe someone's silence as agreement with a particular proposition. In criminal court, of course, you can't do that. If someone chooses not to testify in criminal court, the privilege against self-incrimination under the Fifth Amendment means that the prosecutors can't get up and say,
I'm going to challenge you, though, Professor. Now, say somebody's accused of murdering their wife, and it's not in court, and it's, proceedings have not happened yet, they're a suspect, and you say very publicly to that person, you murdered your wife, and you say it in front of like 10 people, and they just put their head down. Doesn't the law say that an ordinary innocent person in that environment, not in court, would defend themselves and say, no, I didn't do that?
Absolutely. And in fact, in civil court, a refusal to testify can be used against you, and your silence can be constructively ascribed to your agreement with the proposition.
Okay, let me try it one more time. Your bill will deport more kids who are American citizens with cancer.
I don't think they want to answer that.
The silence is deafening.
Would the
It tells
gentleman
us
yield?
everything we need.
Would the gentleman yield?
Yes.
Let's do it a different way. How about this? Raise your hand if you do not think children with cancer who are American citizens should be deported.
If you do not think.
Looks like it's all the Democrats and none of the Republicans. Now, Mr. Swalwell, if I could just continue and ask a question, because you raise an interesting point on the sort of adoptive or constructive admission, especially the distinction between a criminal investigation and a civil investigation. So if a president orders the Department of Justice to criminally investigate his former administration officials because they spoke out against him, does that mean in a criminal context that if they are asked a question and they remain silent, that it can or cannot be used against them?
In a criminal context, it cannot be used against them.
I see. Okay. So they really benefit, I guess, from being under criminal investigation for speaking out against the president, dissenting, as they say. So luckily for them, and I guess unluckily for our colleagues over there who are not under criminal investigation.
They could just speak up and say something.
They could, and they don't get. Okay, thank you. I yield back.
Yield back.
Let's hypothetically, it's not hypothetical, it's true, Donald Trump has a financial interest in a meme coin named after himself. And he recently offered a VIP White House tour and special reception to the meme coin's 25 biggest holders. After that announcement, the coin surged more than 50%. Does that seem like something that warrants investigation to you, Mr. Turley?
Well, there's no question that you can investigate that to see if there was any criminal conduct. I want to distinguish between that and the influence peddling scandal that the hearing was about in the Biden administration.
I'm not talking about that hearing. And I know you like to filibuster, Mr. Turley. No, I'm happy to talk about that hearing. It was the biggest joke of an investigation. It was embarrassing that you call yourself a credible criminal professor, that you would actually think that there was any evidence that warranted an investigation. But I'm focusing right now because it would seem to me, if you have any credibility, you would agree that auctioning off a White House tour for the highest investors in your own company would warrant either impeachment or criminal investigation. But let me move on because it gets worse. The president is a significant financial beneficiary of a company called World Liberty Financial, which issues a stable coin. Are you familiar with stable coins?
I'm not.
Okay, a stable coin is essentially a digital version of a dollar that can be used in transactions. Recently, the World Liberty, this organization which Donald Trump is a beneficiary of, entered into a deal with a UAE-backed company that would complete a $2 billion transaction with a company that has previously admitted to engaging in money laundering. And Donald Trump's company will now generate tens to hundreds of millions of dollars in revenue from that transaction with a foreign government. And I'm sure you're familiar with the Foreign Emoluments Clause, Mr. Turley. Would you say that based on that information, since apparently you only follow Hunter Biden's finances and not President Trump's, would you say that based on me providing you with that information, that would warrant an impeachment investigation?
Congressman, when you say that we have to preserve our credibility, I think you would agree.
Can you answer the question, sir?
He's trying to answer the question. Your time has expired. I will allow the gentleman to answer the question.
Thanks. In the interest of credibility cited by the member, I'm not going to rely on the facts that you just gave me for the first time to render a judgment on it. I'm not opposed to investigations of alleged corruption. That was the point of the previous hearing. But the way to establish credibility is not, as you did, sir, just engage in personality attacks and personal innuendos. I'm happy to speak with you and to work with you about anything dealing with corruption in this building. I've been writing about that for 3 decades. I've been called as a witness for both the Democrats and Republicans dealing with that.
Well,
but the way to presume...
I've only seen you as a witness.
Your time has
for the
expired, sir.
Republicans.
Your time has expired.
I'm happy to yield back.
Did you finish your question?
Only that the way that we can actually regain...
I thought my time has expired.
Your time has expired. I said your time expired. He gets an opportunity to finish answering the question.
I'd like to reclaim my time.
No, you have no additional time. You are out of order.
He's answering
Be quiet.
my question.
You are out of order.
I would like to reclaim
you cannot,
my time.
No. He's answering the question because you personally attacked him. I've said he can answer the question. I give that courtesy.
How did I personally attack him, Mr. Chairman?
You attacked his credibility. We're not going to get into we're not getting into this right now. What we're going to
get? He's a witness. His credibility matters, sir.
You are out of order. You are out of order. You're done. You can't say anything else right now. You may finish answering your question.
Thank you, Mr. Chairman. I think that the one lesson from this exchange is that it's possible that we can restore credibility in this institution if we can just get beyond the personal attacks.
There were no personal attacks, Mr. Turley. You are a witness.
Done.
Your credibility matters.
You, sir, you have lost your credibility with me. I gave that courtesy to everyone on this bench.
Mr. Chairman.
You ask a question. If they wanted to continue to answer beyond the time limit, I said, time's expired, you may answer the question. That's my routine. That's what I did today. You challenged him, asked him a question. You wanted an answer. Your time has expired. He is answering the question.
Mr. Chairman,
You don't like his. You don't like.
inquiry.
You don't like his answer. Because you don't like his answer, you want to shut him up. What's your inquiry?
My inquiry is when you offered when my time was up at 00 for him to answer the question, he went and answered the question. You then gavelled and said my time was up.
That's not a parliamentary inquiry.
You gavelled and
That's
said my
not a
time is up.
parliamentary
I would
inquiry.
like to know when
That's not a parliamentary
my time
inquiry.
is up and when he gets to continue answering
That is not a parliamentary inquiry? Your parliamentarian's about to tell you. That's not a parliamentary inquiry.
He actually disagrees. He thinks it is a parliamentary
That's not a parliamentary inquiry.
Why? I'm asking for the process question, the process question as to when my time is up, which you allowed him to answer the question. You then gavelled and said my time is expired, and then you then offered him to answer the question again, which he already had done.
No, sir. Let us, if we were to watch.
You did it based on accusations that I was personally attacking him, which I was not.
Excuse me. Not only are you out of order, you're being incredibly rude. Here's the deal. I gave everybody the same courtesy. You didn't like where he was going. You began interrupting again, but your time was expired. He was trying to answer the question. You didn't like the answer.
That is false. I'm happy to have this answer.
No, that's what happened.
I didn't like the accusation that I was personally attacking him. His credibility.
I didn't say that till the third round when you interrupted. And you continue to interrupt. You continue to be out of order.
And then I asked you,
are out of order.
I asked you, what am I personally attacking? And you said his credibility, and he is a witness. His credibility matters.
You're out of order. You are so far out of order.
Well, you are not conducting this in a fair and equitable way.
Sure I am.
Because
everybody got the same courtesy. You asked a question, they're going to finish answering. Everybody got that same courtesy. You interrupted him while he was giving the answer. That's why you got gavelled.
And then
you got interrupted.
And then you said
you interrupted.
That's why and then you said my time is up, which is when you would go to the next person.
I gave the same courtesy to every member on your side of the aisle as I gave over here. When your time was expired, 5 minutes expired. If they were in the middle of answering the question, I let it go. Now, we can talk about that round and round all you want. That's what I did. That's what I do.
Well, I look forward to you continuing to do that.
Yeah, well, good. And I look forward to you being in order next time. So, Mr. Turley, you may continue to answer the question that he so much doesn't want to hear.
I've never been so certain in saying I'm happy to move on.
Very good. Thank you.
Thank you, Mr. Chairman. Mr. Turley, it's good to see you again. You are a frequent witness for a variety of different hearings for the Republicans. And in fact, you testified in the last Congress related to an impeachment investigation. And as I recall, you testified that you believed that the Republican investigation related to Hunter Biden's private foreign investments did merit an impeachment investigation against President Biden, I guess based on alleged meetings that the president had with Hunter's business partners, even though there was never any evidence presented that they discussed Hunter's business ventures, or that the president ever financially benefited from those ventures. Is that generally an accurate assessment? You didn't call for impeachment, you just suggested there should be an investigation, right?
The purpose of that hearing was to determine whether there could be an impeachment inquiry and whether if
I'm just asking what you testified, Mr.
I'm trying to say
that. Well, no, did you say directly that there was a legitimate basis to move forward with an impeachment investigation?
Yeah, what I said is that if those allegations were proven, they could amount to impeachable offenses.
All right. Well, let's focus for a second on some conduct that's been going on over the last few months. Related to World Liberty Financial. Are you familiar with that company?
No.
You're not familiar? Okay. Are you familiar at all with Donald Trump's interest in cryptocurrency?
No.
So you're not familiar with the fact that Donald Trump issued a meme coin 2 or 3 days before his inauguration?
I saw something of that in the press, but I'm not that familiar with it.
Okay. Well, let's hypothetically, it's not hypothetical, it's true, Donald Trump has a financial interest in a meme coin named after himself. And he recently offered a VIP White House tour and special reception to the meme coin's 25 biggest holders. After that announcement, the coin surged more than 50%. Does that seem like something that warrants investigation to you, Mr. Turley?
Well, there's no question that you can investigate that to see if there was any criminal conduct. I want to distinguish between that and the influence peddling scandal that the hearing was about in the Biden administration.
I'm not talking about that hearing. And I know you like to filibuster, Mr. Turley. No, I'm happy to talk about that hearing. It was the biggest joke of an investigation. It was embarrassing that you call yourself a credible criminal professor, that you would actually think that there was any evidence that warranted an investigation. But I'm focusing right now because it would seem to me, if you have any credibility, you would agree that auctioning off a White House tour for the highest investors in your own company would warrant either impeachment or criminal investigation. But let me move on because it gets worse. The president is a significant financial beneficiary of a company called World Liberty Financial, which issues a stable coin. Are you familiar with stable coins?
I'm not.
Okay. A stable coin is essentially a digital version of a dollar that can be used in transactions. Recently, the World Liberty, this organization which Donald Trump is a beneficiary of, entered into a deal with a UAE-backed company that would complete a $2 billion transaction with a company that has previously admitted to engaging in money laundering. And Donald Trump's company will now generate tens to hundreds of millions of dollars in revenue from that transaction with a foreign government. And I'm sure you're familiar with the Foreign Emoluments Clause, Mr. Turley. Would you say that based on that information, since apparently you only follow Hunter Biden's finances and not President Trump's, would you say that based on me providing you with that information, that would warrant an impeachment investigation?
Congressman, when you say that we have to preserve our credibility, I think you would agree.
Can you answer the question, sir?
He's trying to answer the question. Your time has expired. I will allow the gentleman to answer the question.
Thanks. In the interest of credibility cited by the member, I'm not going to rely on the facts that you just gave me for the first time to render a judgment on it. I'm not opposed to investigations of alleged corruption. That was the point of the previous hearing. But the way to establish credibility is not, as you did, sir, just engage in personality attacks and personal innuendos. I'm happy to speak with you and to work with you about anything dealing with corruption in this building. I've been writing about that for 3 decades. I've been called as a witness for both the Democrats and Republicans dealing with that.
Well,
but the way to presume...
I've only seen you as a witness.
Your time
for
has
the
expired, sir.
Republicans.
Your time has expired.
I'm happy to yield back.
Did you finish your question?
Only that the way that we can actually regain...
I thought my time has expired.
Your time has expired. I said your time expired. He gets an opportunity to finish answering the question.
I'd like to reclaim my time.
No, you have no additional time. You are out of order.
He's answering
Be quiet.
my question.
You are out of order.
I would like to reclaim
you cannot,
my time.
No. He's answering the question because you personally attacked him. I've said he can answer the question. I give that courtesy.
How did I personally attack him, Mr. Chairman?
You attacked his credibility. We're not going to get into we're not getting into this right now. What we're going to
He's
get
a witness. His credibility matters, sir.
You are out of order. You are out of order. You're done. You can't say anything else right now. You may finish answering your question.
Thank you, Mr. Chairman. I think that the one lesson from this exchange is that it's possible that we can restore credibility in this institution if we can just get beyond the personal attacks.
There were no personal attacks, Mr. Turley. You are a witness.
Done.
Your credibility matters.
You, sir, you have lost your credibility with me. I gave that courtesy to everyone on this bench.
Mr. Chairman.
You ask a question, if they wanted to continue to answer beyond the time limit, I said, time's expired, you may answer the question. That's my routine, that's what I did today. You challenged him, asked him a question. You wanted an answer. Your time has expired. He is answering the question.
Mr. Chairman,
You don't like his answer. Because you don't like his answer, you want to shut him up. What's your inquiry?
My inquiry is when you offered when my time was up at 00 for him to answer the question, he went and answered the question. You then gavelled and said my time was up.
That's not a parliamentary inquiry.
You gavelled and
That's
said my
not a
time is up.
parliamentary
I would
inquiry.
like to know when
That's not a parliamentary
my time
inquiry.
is up and when he gets to continue answering the
That is not a
question.
parliamentary inquiry? Your parliamentarian's about to tell you. That's not a parliamentary inquiry.
He actually disagrees. He thinks it is a parliamentary inquiry.
That's not a parliamentary inquiry.
Why? I'm asking for the process question, the process question as to when my time is up, which you allowed him to answer the question. You then gavelled and said my time is expired, and then you then offered him to answer the question again, which he already had done.
No, sir. If we were to watch.
You did it based on accusations that I was personally attacking him, which I was not.
Excuse me. Not only are you out of order, you're being incredibly rude. Here's the deal. I gave everybody the same courtesy. You didn't like where he was going. You began interrupting again, but your time was expired. He was trying to answer the question. You didn't like the answer.
That is false. I'm happy to have this answer.
No, that's what happened.
I didn't like the accusation that I was personally attacking him. His credibility.
I didn't say that till the third round when you interrupted.
His
and you continue to interrupt. You continue to be out of order.
And then I asked you,
are out of order.
I asked you, what am I personally attacking? And you said his credibility, and he is a witness whose credibility matters.
You're out of order. You are so far out of order.
Well, you are not conducting this in a fair and equitable way.
Sure I am.
Because
everybody got the same courtesy. You asked a question, they're going to finish answering. Everybody got that same courtesy. You interrupted him while he was giving the answer. That's why you got gavelled.
And then
you got interrupted.
And then you said
you interrupted.
Time,
that's why
and then you said my time is up, which is when you would go to the next person.
I gave the same courtesy to every member on your side of the aisle as I gave over here. When your time was expired, 5 minutes expired. If they were in the middle of answering the question, I let it go. Now, we can talk about that round and round all you want. That's what I did. That's what I do.
Well, I look forward to you continuing to do that.
Yeah, well, good. And I look forward to you being in order next time. So, Mr. Turley, you may continue to answer the question that he so much doesn't want to hear.
I've never been so certain in saying I'm happy to move on.
Very good. Thank you. Now, I'll yield to my...
I now recognize Mr. Goldman for 5 minutes questioning.
Thank you, Mr. Chairman. I would like to go back to Mr. Kilmar Abrego Garcia's case, Madam Secretary. But my first question for you is a pretty simple one. It's basic civics. Which branch of government does the Constitution give the authority to interpret what the law is, the judiciary or the executive branch?
Sir, going forward, the interpretation of the law, you make the laws in this body. The judicial branch makes sure that they have integrity and they're applied properly to individuals.
So I'm just going to take that as the judiciary branch. Now, let's focus for a second on what the judiciary branch has said about this case. We know the Supreme Court has said 9-0 that notwithstanding your statements under oath here today, that Mr. Kilmar Abrego Garcia was afforded due process, he was in fact not afforded due process, because then if he were, you would have seen the withholding order that did not permit him to be deported to El Salvador. Now you allege, and I guess the Attorney General alleges, that he's a member of MS-13. That may very well be the case. And if he is, now that that is a foreign terrorist organization, certainly the immigration laws would allow him, and in fact require him, to be deported. I certainly would support that. But the problem that we have here is what you allege, what Ms. Green alleges, what the Attorney General alleges, is not the judiciary. You don't get to decide whether or not he is an MS-13 member. And you don't have to take my word for it, because Judge Wilkinson, a Fourth Circuit judge, very conservative, addressed this argument. He said, the government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident in its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. Will you commit right now to give Mr. Abrego Garcia that process where you can prove your allegation that he is a member of MS-13?
Congressman, that judge that you just quoted did not say he was not a member of MS-13. Who did say that he was a member of MS-13 was law enforcement officers that encountered this individual.
Yeah, he knows
We
that.
had
This is a Fourth Circuit judge. He knows all of what the evidence is, and he's saying if that evidence.
So
you're not going to commit to follow this order. You won't commit to follow this court order.
By the way, he identified
Madam Secretary,
himself.
I reclaim my time. Stop filibustering. Stop filibustering.
He was surrounded by gang members of MS-13.
Will you give Mr. Abrego Garcia the due process that the Supreme Court and Judge Wilkinson has required you to give him?
Abrego Garcia is an El Salvador resident who is in his home country. If he were to come back to this country, he would be immediately removed again.
How do you know?
He has received and been treated appropriately,
So
sir, and he is not.
How can
in
you
this
say he's
country
been
anymore.
treated appropriately if the Supreme Court has ruled 9-0? 9-0 that he hasn't been treated appropriately. Why is your opinion better and have more authority than the Supreme Court?
Investigators, 2 judges, an immigration court that all said he was MS-13 and was removed from this country.
But you understand, that is you saying that. That is you saying that.
That is them saying that. This
No,
is
no, no, no.
investigators and law
That is
enforcement
you
officers
making that
and the case they
determination.
built against him. If you don't
The
trust our law
court
enforcement
has
officers
considered all that.
and
The judge has
investigators,
considered all that,
then
Madam
who do you
Secretary.
trust if you
And
don't
if you would be
trust judges?
quiet, because I'm reclaiming my time, you are not following this court order. But let's focus on the court order, because this opinion also says that to facilitate, which the Supreme Court is requiring, is an active verb. It requires that steps be taken. What steps have you taken to return Mr. Abrego Garcia to allow him to get due process?
Abrego Garcia is in his home country.
What
If he were to come
steps
back,
have
your
you
advocacy-
taken?
If your continued advocacy for him were to...
I'm not advocating for him.
Yes, you
I'm
are.
advocating for a
Absolutely.
court order, Madam
Gone to the
Secretary.
mat for this
The
man
court
who
order
has terrorized
says
people
that
in
you
traffic,
must take
human
steps
beings.
to follow the court order. You are here under oath. What steps have you taken to return Mr. Abrego Garcia pursuant to this court order?
It's got to be extremely discouraging to be one of your constituents. To see you fight for a terrorist like this and not fight for them is extremely alarming to me.
I'm fighting for due process, and that's under the Constitution,
Gentleman's
and you
time
should
has
fight too for due
expired.
process.
The gentleman's time has expired. I now recognize.
And that no one is treated differently than someone else.
Gentleman's time has expired. I now recognize Mr. Guest from
Mr. Chairman,
Mississippi.
Mr. Chairman, I ask unanimous consent to enter for the record the Prince George's County Police Department gang field interview sheet in Maryland, from 2019, where they interviewed Kilmar Abrego Garcia and identified through his clothing that he, and his statements, that he is indeed an MS-13 gang member.
Without objection.
I'd also
So
ask.
ordered.
I also ask unanimous consent to enter for the record an article that quotes Kilmar Abrego's wife stating, "I am afraid," with another protective order filing against deported Maryland man championed by the Democrats. Thank you, Mr. Chairman.
Mr. Chairman, I have a unanimous consent request.
Without disagreement, we'll put that one in as unanimous consent. You're recognized.
Mr. Chairman, if you have it, I would like to introduce by unanimous consent a court order establishing that Kilmar Abrego Garcia is a member of MS-13.
You're submitting what for unanimous consent?
Well, there isn't one, so I'm wondering if you have.
I do not have that. Okay. Are we ready to go on with the next testimony? Mr. Guest, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Madam Secretary. Without objection, the reading is dispensed with, and the gentleman, Mr. Carter, is recognized for 5 minutes to speak on his amendment.
Thank you, Mr. Chairman. Last week, 3 little children who are citizens of the United States of America and citizens of the state of Louisiana were unconstitutionally detained by ICE, then unconstitutionally trafficked out of this country to Honduras. One of those little children is a 4-year-old boy with a rare form of cancer. It's stage 4, and that little boy is going to die if he doesn't get back to the United States where he belongs. I'm shocked, and it takes a lot to shock me these days, that I even have to propose this amendment to prohibit funds from being used to deport minor children who are citizens of this country. But unfortunately, we're here. Look, it's already illegal to deport citizens. As federal courts have said, quote, any ICE officer would know it is illegal and unconstitutional to deport, detain, for deportation or recommended deportation a U.S. citizen, end quote. Moreover, to quote federal courts, an ICE officer who actively participates in the detention and or removal of a person who he knows to be a U.S. citizen or upon minimal investigation would discover is a U.S. citizen would be deemed to know that such conduct clearly denies that person's liberty without due process, end quote. So the ICE field office director in New Orleans and every ICE officer who aided or effectuated the removal of these little citizen children from the state of Louisiana to Honduras were trampling on the Constitution. They said, to hell with it. Can't say that about our Constitution. Congress cannot allow taxpayer dollars to be spent for unconstitutional actions that harm little children who happen to be U.S. citizens. I've seen people on the internet and some of my Republican colleagues say that children's mothers somehow consented to the deportation of their children. Let me dispel this myth. First of all, as a Trump-appointed judge in Louisiana said, quote, the court doesn't know that, end quote, because the Trump administration refused to pick up the phone when the judge called to speak to one of the mothers about her so-called consent. Second, a mother cannot give meaningful consent to the deportation of her citizen children while she is under duress and held by ICE with no access to her lawyer, while her lawyer is pleading with ICE to get into the room, and while she cannot get into contact with the children's father. What is a mother to do if she doesn't know whether ICE will let her kids go on the side of the road or just house them in a different cell to suffer alone? There's no lawful consent that could be given under those circumstances. Third and finally, the father of these children did not consent to their children's unconstitutional deportation to Honduras. To quote the Supreme Court in Troxel v. Granville, quote, the liberty interest of parents in the care, custody, and control of their children is perhaps the oldest of the fundamental liberties interest recognized by this court, end quote. Yet again, ICE and DHS ignored the Constitution and deported children citizens. What is fascist hell has this country become in just the first 3 months of the Donald Trump presidency? Let me repeat that. What in fascist hell has this country become in just the first 3 months of Donald Trump's presidency? We cannot sit back and let ICE deport citizens, especially children. My tiny constituents may die in a foreign country because of the ICE field office in New Orleans and the actions of the Trump administration, which Republicans apparently want to spend more money on. Where is the human decency? Let's get these citizen children back. Congress has planes. We should go get them, bring them home from Honduras, get these children back home to their fathers.
Gentleman's
Instead,
time
we're
has
trying to
expired.
risk and
Does
get
the
them
gentleman
into the
insist
hands
upon his point of order?
of hospitals. where
Gentleman's
they
time
can't
has
live.
expired. Does Mr. Guest
Mr.
insist
Chairman,
upon
I
his point of
yield.
order?
I withdraw my point of order.
Point of order is withdrawn. Do any other members wish to speak on this amendment?
Mr. Chairman.
Mr. Magaziner is recognized for 5 minutes.
Mr. Chairman, I speak in support of Mr. Carter's bill. It is outrageous that the Trump administration is deporting children who are U.S. citizens and pose no threat to the United States. What world are we living in where my Republican colleagues are willing to accept this? And I just want to add some context here. As far as I'm aware, in none of the cases where U.S. citizen children have been deported were their parents accused of any crime in the United States, pose any threat to public safety, and it seems that they were denied the opportunity to even consult with a lawyer before they and their children were deported. April 24th in New Orleans, U.S. citizens aged 4 and 7. The 4-year-old has a rare form of late-stage cancer. The mother was not able to speak with family members or any lawyers before she and the children, including the U.S. citizen child with cancer, were deported. Not even allowed to talk to a lawyer. That U.S. citizen's rights were denied. Family number 2, April 22nd, a 2-year-old U.S. citizen deported to Honduras with his mother and sister. Now picture that you are the father of this 2-year-old. The father, and we know this from legal filings, the father received a call from an ICE officer who said that the mother was there and that they did not have much time to speak, but they were going to be deported. The father was able to speak with the mother for only a minute. He heard his daughters crying in the background. He told the officer that their daughter was a U.S. citizen and could not be deported. The officer said that the daughter would not be deported. The father began to give the mother the phone number of their attorneys, but before he could, he heard the officer take the phone from her and hang up the call, and they were all deported, including the 2-year-old U.S. citizen. No opportunity to speak with a lawyer. Barely any opportunity at all to speak with family. Why? What was the urgent threat posed by this 2-year-old? None. And this is the slippery slope. They start with people who are undocumented. Then it's legal immigrants in the United States. Then it's U.S. citizens who are 2 years old. If they keep trampling on rights, pretty soon, everyone's rights are going to be under threat. This is how it happens. We have to draw the line. So if nothing else, can we at least come together as a committee and as a Congress and say no to deporting children who are U.S. citizens, especially when no access to legal counsel has been afforded? Can we at least do that? And I yield back.
The gentleman yields. Do any other members wish to speak on this amendment?
Mr. Chairman.
Ms. Thompson is recognized.
Thank you very much. It must be really tough for my colleagues on the other side to vote against this. I mean, I'm a father, I'm a grandfather, I'm a godfather, I'm an uncle, I'm a cousin to children, and who are all American citizens. And all we're saying is, say, look, don't do children this way. Through no fault of their own, we're going to deport them. And I would hate if somebody did a relative of Benny Thompson's like that, or a relative of anyone else's like that. We are a better country than what's being exhibited in this bill. Just being mean to children is not the way to go. I encourage my colleagues to support this amendment. It makes sense. Children didn't ask to be born in this country. But if they are, they should be afforded every right that an American citizen is provided. And it can't be just based on innuendo or what somebody said. We talked about the said a mother said. Well, we don't have proof other than what the other person said. There's no video, there's nothing. And so I think what we have to do is err on the side of what makes sense. We're a nation of laws. Children are here. It's a blessing to have them if you're fortunate. But you also have other children that you help with. And so I implore my Republican colleagues, do a little soul searching before you vote against this bill, because it's absolutely tough, I think, to vote against children. Most elected officials will say that children are some of the people we have to support. This is an amendment that supports children. We should not be about punishing children who have not broken the law. Being an American citizen is not illegal. Therefore, you should not be deported. So I ask my colleagues to support the amendment made by the gentleman from Louisiana. Yield back.
The gentleman yields. Any other members seek recognition? There being no further discussion, the question now occurs on the amendment offered by Mr. Carter of Louisiana. All those in favor say aye.
Aye.
All those opposed say no. No. In the opinion of the chair, the noes have it, and the amendment to the amendment in the
Mr.
nature of
Chairman.
a substitute is not adopted. Mr. Thompson is recognized.
On that, I ask for the yeas and nays.
Recorded vote is requested pursuant to Committee Rule 7C. Further proceedings on this question are postponed. Are there any amendments to the amendment in the nature of a substitute to be further considered? Mr. Magaziner,
Mr. Chairman.
you have an amendment at the
Yes,
desk?
Mr. Chairman, I have an amendment at the desk.
Mr. Guest?
Chairman, I seek recognition. I reserve a
Gentlemen.
point of order.
Gentleman reserves a point of order. The clerk will distribute the amendment. The clerk will report the amendment.
An amendment to the amendment in the nature of a substitute to the committee print by the Committee on Homeland Security, offered by Mr. Magaziner, number 023.
Without objection, the reading is dispensed with. The gentleman, Mr. Magaziner, is recognized for 5 minutes to speak on his amendment.
Thank you, Mr. Chairman. My amendment is a simple one. It aims to prevent President Trump from sending United States citizens to foreign prisons like the prison in El Salvador. As United States citizens, we have inalienable rights: the right to due process, the right to free speech, and the right not to have our own elected leaders send us to foreign prisons and then claim that those rights no longer apply. If it can happen to someone else, it can happen to you. And I would just urge my colleagues on both sides of the aisle. I know we don't agree on everything, but if we can agree on nothing else, can we at least agree on not sending U.S. citizens to rot in foreign prisons? And this is not an idle possibility. President Trump has repeatedly stated that he wants to send U.S. citizens to prisons in El Salvador. He said to the president of El Salvador, quote, "I said the homegrown's next, the homegrowns." Elon Musk said, "Great idea." And Trump said, "I'd do it in a heartbeat." Donald Trump has instructed the Attorney General to look into deporting U.S. citizens to other countries. During a White House press briefing, the White House spokesperson said that the president has been discussing this idea quite a few times. Can we just cut this off now? Let's not send U.S. citizens to foreign prisons. This is insane. It is outrageous. And every American should be terrified by this prospect. What we have right now is an out-of-control president who believes that the law does not apply to him, who believes that he is above the Constitution, but no, we are a country of laws, we are a country where every U.S. citizen is protected under the Constitution, and U.S. citizens should not be sent to foreign jails. So I'm just going to stop there because this is simple, it is cut and dry, and I would just urge all my colleagues, you're going to have to vote on this. And think about how that vote is going to age over time. If U.S. citizens are sent to be tortured and possibly die in a foreign jail because we allow it to happen, how is that vote going to age? Let's just cut this off right now. It has nothing to do with making the border more secure. It has nothing to do with making our country safer. This is about protecting the fundamental rights of American citizens. It's about protecting the Constitution that we all swore an oath to uphold. Let's do the right thing here. And I yield back.
Mr. Chairman,
The gentleman yields. Mr. Guest, you recognized.
I'd like to withdraw my point of order.
The gentleman withdraws his point of order.
Mr. Chairman, may I be recognized?
Mr. Goldman, you wish to speak on this amendment?
Yes, I do.
Mr. Goldman is recognized to speak on the amendment.
Thank you, Mr. Chairman. We're dealing with an amendment that at its core relates to using U.S. funding, U.S. resources to pay for people who are in this country to be housed at one of the most brutal, cruel prisons in the world. This prison would violate the Eighth Amendment if it were in the United States. Of course, it's not in the United States, so there is no Eighth Amendment in El Salvador. And I bring this up because even though Mr. Abrego Garcia is not a citizen, and so this amendment itself does not directly relate to him, the idea that the President of the United States would say, I have no ability to bring him back from an El Salvador prison when we are paying for him to be there. And you don't have to take my word for it. The Vice President of El Salvador said to Senator Van Hollen when he went down there, well, why are you keeping him? Because we're being paid to keep him here. And if we weren't being paid, then we would happily turn him back over. So let's call a spade here. We all know that it is entirely false and bogus to claim that he cannot be returned to the United States from El Salvador. Let's just agree, can we all, that that is not actually the reason why the President of the United States has defied a 9-0 Supreme Court order. And I think we should also be able to agree that the word facilitate means, as very conservative appellate judge Harvey Wilkinson said, to actually do something. How about doing something by stopping payment for Mr. Abrego Garcia's incarceration? That would certainly be facilitating. That is sufficiently easy enough, and that is at the power of President Donald Trump to do. So let's get rid of this fiction that he can't be brought back. He can easily be returned by President Trump. At a Judiciary Committee hearing a couple of weeks ago, even former Speaker Newt Gingrich acknowledged that given the admitted mistake, quote unquote, of deporting Mr. Abreu Garcia to a country where there was an order that he should not go to, he said he should be brought back. Why can we not all agree that he should be returned to this country to go through due process? I don't know whether he's a member of MS-13 or not, but neither does the president, and he doesn't get to decide that. In our country, a court gets to decide that based on evidence presented to the court. So I urge, once again, my Republican colleagues to speak up, to urge the president. You could even do it privately. You don't even have to do it in public. But I urge you to call over to the White House and to encourage the president to correct his own admitted mistake and return someone so they can get the due process that they deserve, that the Supreme Court has said unanimously. Such far-left activist judges as Justice Kavanaugh, Justice Alito, Justice Thomas, Justice Gorsuch, Justice Coney Barrett, 3 of whom Donald Trump nominated, they all say he needs to be brought back because of due process. And you all sit silently while he defies the Supreme Court order. Come on. You're better than this. I yield back.
Gentleman yields. Would anyone else wish to speak on the amendment? Ms. Ramirez, you're recognized.
Thank you, Chairman. I just, for the record, want to actually read the amendment that the gentleman from Rhode Island has entered for a vote. It's very simple, and let me read it into the record. None of the funds made available by this title may be used by the Department of Homeland Security, its employees or contractors to aid, promote, or effectuate the detention or incarceration in a foreign prisoner of any citizen of the United States, except in compliance with treaty obligations and federal extradition laws and policies. I just need to make sure, as our constituents are listening, what my colleagues are about to vote on. I don't know how many of you, when you were campaigning, you said, listen, and I'm going to make sure that we're also going to be using your taxpayer dollars to deport you if you're not in agreement with the President of the United States. I don't think any of you said that. But the idea that you would actually go on record to vote to deport U.S. citizens to a prison like Sika is unconscionable to me. You have said that you have signed an oath to protect the Constitution, and you would actually go as far as saying, in a time that you're saying at town halls, well, listen, we have a deficit, we are broke, that you're going to use taxpayer dollars to deport United States citizens. It just seems unimaginable. So what I'm asking of you is to affirm the idea that your constituents are smart and they're watching and they read. And what this amendment says, pretty simple. It shouldn't even have to be an amendment because it's constitutional. The Department of Homeland Security cannot use the taxpayer money, the money that has been appropriated for Social Security, for Medicaid, to deport United States citizens. You said that you had a problem with people coming here the illegal way, but now you're willing to deport United States citizens to a prison, which, by the way, its own government officials have said on record, you cannot leave, and if you leave, you're leaving in a body bag. So just for the record, you're about to vote to authorize the Department of Homeland Security to deport United States citizens to foreign prisons in which the government itself of these countries have said you cannot leave that prison, and if you do, you're leaving in a body bag. I just want to make sure that I put that on the record as you're thinking about why you ran for office, who you represent, and representing and upholding the Constitution. With that, I yield back.
Gentlelady yields. I now recognize the ranking member.
Thank you very much, Mr. Chairman. Again, this is a common sense amendment. It's unfortunate that we have to offer it because it's already in law. But if we have to try to prevent monies being spent in support of an illegal act, then so be it. As a child in elementary school, we learned the Pledge of Allegiance to the flag. A lot of our members wear flags in their lapel, talks about how much they love America, how much this democracy is great. But one of the tenets of this democracy is that not only if you are accused of something, you get to face your accuser, you get to provide an adequate defense. If you can't, we'll help pay for it because we want to give you the benefit of the doubt. What we've done is taken the benefit of the doubt away from American citizens and said, it doesn't matter. If you don't look like somebody, we'll deport you. If you do look like somebody, we'll still deport you. That's not who we are. And it's so unfortunate because I would not question anyone's patriotism on this committee because you signed an oath after being elected to this office to do and follow the law. But clearly, what's the problem with saying you can't deport American citizens? What's the problem with saying we're not going to spend any money deporting American citizens to a foreign country? In some instances, they've never been there, don't know anyone. And being mean doesn't make you legal. So I encourage my colleagues that at some point when we vote, you could have a constituent or someone in this same situation, could be a family member, and you'd want every opportunity for the law to prevail in keeping that person here in America. I encourage you to think about it, and it's really almost an embarrassment that we have to make an amendment that's already the law. And the fact that you're going to vote against it for whatever reason other than Donald Trump is telling you, you either vote my way or I'm going to primary you come next election. But you know, this is America. We have to stand on principle. One man can't run everything. One man can't have his way in every instance. One man can't be right 100% of the time. And I just can't understand how adults, for whatever reason, won't challenge a president when they know that president is wrong. I yield back.
Gentleman yields. Would anyone else care to make a comment on the amendment, to the amendment? Hearing none, the question now occurs on the amendment offered by Mr. Magaziner. All those in favor say aye. All those opposed say no. No. In the opinion of the chair, the no.
Gentleman yields and I now recognize the gentleman from New York, Mr. Goldman.
Thank you very much, Mr. Chairman. I think you raised a very interesting point, Mr. Jordan, Chairman Jordan, wanting to make sure that a warrant is obtained to search Americans' data. So I recognize we're here focused on the Cloud Act, and it's an important issue. I don't dispute that. But in the times we're in, this seems quaint and intellectual, academic discussion. And in reality, what we're dealing with is an administration, current administration, that is trying to categorize, gather, and streamline data of Americans given with access by a private company. Now, let me explain a little bit, and I want to ask some questions. Many of you, I'm sure, have heard of Palantir, which is a large data company, has a lot of connections to Elon Musk to Doge. And in March, Donald Trump issued an executive order that would increase the sharing of all unclassified data between and among federal agencies. It directed agency heads to authorize and facilitate both the intra and interagency sharing and consolidation of unclassified agency records. Now, a New York Times report in May outlined in great detail how the president has employed Palantir to carry out this executive order, essentially to merge all data from all different executive branch agencies into one single database. Now, it's unclear who would control that database, who would have access to it, what searches would be done, and there seem to be no guardrails about that. Another New York Times article says that the administration, that this database would have 314 different points of data about every American. Literally every American, 314 various categories of data will be consolidated into one database by a private company, Palantir. Now, my colleagues on the other side of the aisle often express concern about government surveillance, about ensuring that we get search warrants in the context of 702, which is a small universe of already obtained information that we know are communications with people of interest from of foreign nationalities. Here, we just have every American's data put into one database with no guidelines, no restrictions. We don't know what Palantir is doing. We don't know what Doge is doing. We don't know what Elon Musk is doing. It essentially creates a one-stop shop for all Americans' data, which, as we're talking about cybersecurity, I'm sure you all agree that creates a tremendous cybersecurity risk if China or Russia were to hack this. Now, the chairman of this committee has said in the past, quote, Congress has struggled, of this subcommittee, Mr. Biggs, Congress has struggled for 4 years with a corrupt presidential administration, meaning the Biden administration, that further expanded the opportunities for the government to spy on its citizens. So, there was nothing in the Biden administration that approximates this collection of data, this opportunity for the government to spy on its citizens. And I'm not even talking about breaking laws under the tax code and sharing tax information with immigration enforcement agencies. I'm not even talking about sharing the tax information or Social Security Administration information. This is just every piece of data that is out there in the government's control, consolidated with one private company and one database. And so I would ask my friend, Chairman Biggs, to think about whether, if you are truly worried about government surveillance, why are we not doing any oversight of Palantir, its contracts with the government, its consolidation of all Americans' personal information into one database and the cybersecurity risks? And I really hope, in all seriousness, that you will do oversight over that if you do truly care about government surveillance of citizens. And I yield back.
Gentleman yields back.
I yield back, Mr.
Will the gentleman yield?
Gentleman yields back. Chair recognizes Ms. Luna
Mr.
from
Chairman,
Florida.
point of inquiry, did you skip me in the order on purpose? Just curious.
It must have been an oversight, Mr. Moskowitz.
Well, this is
So
the
Chair
oversight
recognizes
committee,
Ms.
which
Luna.
has lots of oversight.
Gentlemen, please.
Chair
I'd like to ask
recognizes
my
Ms. Luna.
I just, suppressing free speech.
It's Ms. Luna.
Thank you very
You're
much,
recognized.
Chairman. First and foremost, I would like to take this opportunity to educate the American people on what's really happening right now with these riots. So I see right now there's a lot of back and forth and finger pointing, but the fact is that there is a financial tie to these riots, tied to immigration, that actually leads right back to the Communist Chinese Party. Straight up, the LA riots have been organized by an organization dubbed PSL, the Party for Socialism and Liberation.
funded by billionaire Chinese activist Neville Singham, who spends parts of his year by living in Shanghai. In addition to that, although he is not a registered foreign agent, he accepts a lot of money from the CCP and then turns around and funnels it right into some of these violent protests that we're seeing. But it doesn't just stop there. This is not the only organized protest that's using brown people and immigrants as a ruse to push their communist and Marxist agenda. Mr. Waltz, thank you for coming in today to testify, or Mr. Walls. Real quick, is it true, yes or no, that you are speaking at the June 14th Twin Cities No King rally?
I can't confirm that right now. That
Okay.
could be true.
Okay. Just so you know, they're advertising you speaking there.
Okay.
The graphic's actually on X right now. I'd be happy to provide it for you, so I'll take that as probably speaking. Is it true also, I know on your campaign, that you had admitted to visiting China anywhere from 15 to 30 times, sir? Yes or no, please?
I did live in China and
No, visiting, sir, in addition to living there and in addition
Yes,
to having, okay.
that's correct.
All right, also too, I'd like to note that during your time in Congress that you filed for a $5 million earmark that actually was secured. $2 million of it went to the Harmel Institute that actually collaborated with the Wuhan Institute. Also, the Department of Homeland Security, sir, just to you, so that you're tracking, actually had an internal memo that was released that stated that the government of China considered you a prime target for influence operations. I'm letting you know that now because I do believe that you should be made aware of, if you are not already, that you are working with and going to be speaking at an organization and rally that not is just funded by Christy Walton, the heiress of Walmart, but also has ties to the Chinese Progressive Association, largely funding it, that actually brags on their website that they are pro-Maoist. Also, too, funded by the National Endowment for Democracy. I know there's a lot of people on this committee that don't like billionaires interfering in politics, but say nothing when George Soros gets over $260 million from USAID through the last administration that's then funneled into some of these nonprofits and organizations. So I guess my question for you guys is, now that I've made you aware that these riots are not about illegals and they're not about immigrants, if they did, they would have been protesting under Barack Obama, who's also dubbed the deporter-in-chief. And frankly, I think many of you would say that Barack Obama was a good president. Are you going to say that Barack Obama wasn't a good president? Yes or no, Governor Waltz? Do you think he was a good president?
Do I think Barack Obama was
Correct.
president? I think he did a good job.
Okay, how about you, Governor Pritzker?
I think he did a good job, yes.
Hochul?
Hochul, and yes, he did do a good job.
Okay, next. Perryman?
I think President Obama did a good job.
So then you would understand that Barack Obama had the very same policies, for the most part, on immigration that Republicans are parroting today, and yet you guys are sitting here saying that we're Gestapo. And what I would tell you is that what happens with open borders is that the real people that are coming here, the ones that are exploited, actually it hurts people on both sides, not just Americans, but the illegals. Some of you had said here to the actual committee that you are doing what you can to assist these people, but what I would say is that your policies aren't actually done from a place of understanding and sympathy. I would say that it's actually doing the exact opposite. And when you use brown people, just like they use black people with BLM and Marxists during BLM to usher that in, when you use brown people and you put Mexican flags with them saying that you stand up for illegal immigrants, but you follow the money and it's going back to the Communist Party, what you're essentially doing is using your platform as elected officials, the trust that the American people have put in you, essentially to usher in communism. You're not actually fighting for American values. Don't roll your eyes, because it's a serious topic and that's where the money's coming from. So now I'm informing you, so now you guys can make your decisions, but please be informed, sir, Mr. Walls, that if you truly do uphold the American ideologies and perspectives on the Constitution, you should not be speaking at that rally. I've given you the correct information, and as of right now, I've authorized a letter to be sent to my office to the President of the United States to rescind millions of dollars in funding that we know are going to the No Kings protests that were authorized and basically given under the last administration. That is what Congress is supposed to do, not point fingers, not blame people, but actually ensure that the American people are protected and not fighting for foreign interests, foreign governments, and also the communist
Will the gentlelady yield for a question?
No.
You don't want to tell us what your evidence is of all this connections?
Actually, no, I will yield
You know,
to that.
I appreciate
No,
Mr. Goldman,
no,
you'll
wait,
get
I
5
will-
minutes. Take your
let
word
me answer
for
the
it.
question.
But
Let me answer
you'll
the question.
appreciate we might want actual evidence.
I would be happy to provide that, and I'd also be happy to inform Chairman that actually we have a letter of which you can sign on to. I know you like to sign on to letters with us, especially on the Epstein stuff. But we actually have a letter going out to Neville Singham on Friday, and it's actually signed by every single member of Oversight. I'd like to extend that to you because that letter is calling him to testify, and it's also calling for his financial transactions. And do you agree, sir, that we should not be accepting money from the Communist Chinese Party? I think anyone on this platform would agree that that should not be accepted, correct?
I would like for you to actually present
We are,
evidence
and we're
rather
having-
than just,
yes.
quote, inform the witnesses, and now that they're informed, they
Look,
should assume
I
what
don't
you
disrespect
say is
you. I'm
true
going to answer your
when
question.
it
We
is
are having a hearing on it where we
repeatedly
can
debunked. It's
present
the
all the
right-wing
evidence.
Order.
ecosphere.
No, but let's have this
Yeah,
dialogue. I
go
appreciate
ahead.
the
You're
question.
recognized, Ms. Luna.
We are going to be having a hearing, and you can gavel on to the hearing. I'd appreciate you to do it because the fact is that the Democrat Party, remember,
Is
look,
it going to be as good as the Biden impeachment hearing?
Mr. Goldman, you'll have
let's
5
focus-
minutes in a
let's keep it
moment.
focused real quick.
Well, Mr.
I'd
Chairman,
like to
she's
go
out
a
of
step
time. I just think
further.
you're trying not to let me talk.
Guys, if you guys want to talk about it, I'll answer the question. But Mr. Singham is also funding Code Pink through his wife.
You know, it's my turn.
And
Can we ask Elon
All
to
right.
divest
I know
from
you know
China
it.
while we're at
The
it?
lady's time's
Ties there.
expired. The
That's right.
lady's
Thank you
time's
very much. We'll
expired.
be having the hearing. Y'all are invited. We might have you guys
All right,
back.
thank you. Before we go, Chair recognizes Mr. Jack. Okay, wait a minute. We did 2 Republicans, so we're going to go to Mr. Goldman.
Thank you, Mr. Chairman. I would urge you to reserve comment on what happened to Mr. Padilla until you get full information. In fact, I would urge all of my Republican colleagues to take a breath before you once again desperately run to bend the knee to Donald Trump and to Kristi Noem. Because anyone with 2 eyes that can see that that was authoritarian, lawless behavior that no person in America, much less a senator conducting constitutional oversight, should have received. And I know it's hard for all of you to speak up against Donald Trump, and that's why we're here at this hearing talking all about Joe Biden, talking all about Joe Biden's policy this, Joe Biden's policy that, all these people who committed crimes under Joe Biden. Is it just because you're consistently trying to ignore the fact that Joe Biden is not president? Donald Trump is president. And what he's doing right now, which you all know, is he is going after people who are lawfully present. Now, I appreciate the governor's being here. I'm sorry you have to deal with this crap. Governor Hochul, especially, I want you to know, as a proud member of the delegation of your state, I am not going to use my 5 minutes to mount a campaign for governor against you, as my colleague from the North Country chose to do. I will give you the opportunity to actually answer some questions, unlike she did. And I will allow you to explain exactly what the policies in New York are as it relates to cooperation between the state and federal agents.
First of all, glad you're not running against me. Thank you. Secondly, I appreciate the opportunity to break through all the noise here today and to stop the talking points that keep mischaracterizing our policies in the great state of New York. New York is not a sanctuary or a haven for criminals. We devote an enormous amount of our energy working to keep New Yorkers safe. $2.5 billion I've allocated just in the last few years. We do cooperate with ICE when it comes to investigating or building a case against criminals. We do this all the time. And when someone goes through the criminal justice system in the state of New York, they do their time in prison. We alert ICE as to when, 30 days in advance of when they're to be removed, and we send them away. That's how it's supposed to work. But what we do not do under our laws is divert our essential resources to protect everyday New Yorkers from crimes themselves and have that help ICE with civil immigration enforcement. That is their job. That is the federal government's job. And we cannot be told to enforce federal laws. It's not constitutional.
Or to use all your limited resources to spend all that time doing their job.
My concern is that every minute that ICE officers are going after moms and dads and kids and separating families, perhaps one more criminal is still out there at large.
Well, it's
Why
funny
don't you
say
focus
that.
on
I'm
them?
sorry to interrupt you, because I actually, in my district office down in Lower Manhattan, witnessed ICE officers waiting for immigrants to come out of a courtroom. These are immigrants who have asylum applications. And I'm sure you agree with me that asylum is a lawful pathway to immigrate to this country. Is that correct?
That is absolutely correct.
So in order to make these immigrants here unlawfully, the DHS is now dismissing their cases, their own removal proceedings against them, to void out the asylum process, the asylum claim. That way, when they go downstairs in the elevator, there are ICE agents that can be there and to arrest them and put them in expedited removal. And they don't have an asylum claim that is live anymore because they've just voided it out. These are non-criminal, these are non-violent immigrants who are here going through lawful process. And this is who the Trump administration is going after every single day. It's a disgrace. You said you were going to go after the worst of the worst. You were going to go after convicted criminals. You're here questioning about all these criminals. You're going after people who actually are going through the lawful process you say they should. But just because Donald Trump and Stephen Miller need to bump up their numbers because they can't do a good enough job in actually finding convicted criminals, you're going after moms, dads, separating parents from children. You have a voice, Republicans. Speak up. I yield back.
Now chair recognizes Mr. Jack. Gentleman yields. Mr. Goldman is recognized for questioning.
Thank you, Mr. Chairman. Here we are again, La La Land and Homeland Security Committee, conducting oversight of the president and his administration. Great, because there are many, many things that Congress should be conducting oversight over this administration. Donald Trump campaigned on finding convicted criminals who are unlawfully here in this country and deporting them. The worst of the worst, he said. Instead, he and his unidentified masked secret ICE agents are snatching and arresting immigrants from court proceedings, nonviolent, non-criminal immigrants pursuing legal pathways to immigrate to this country, and then illegally detaining them in horrific conditions, and even possibly deporting them despite the fact that they are here legally. You would think the committee with jurisdiction over the Department of Homeland Security would want to conduct oversight over the department's refusal to allow members of Congress to observe the conditions of DHS detention facilities. In fact, there is a specific statute that authorizes both Republicans and Democrats to conduct oversight over facilities that house or detain immigrants. But no, the department refuses. So we're here in the Homeland Security Committee, and I'm sure the Republican majority does not like it when this administration undermines its own authority, its own statutory authority, to conduct oversight. But no, instead of all of that, we are here talking yet again about Joe Biden. Newsflash, Joe Biden is not the president. He hasn't been the president for 7 months. So if we are going to conduct oversight here, why are we doing it about the Biden administration when this administration is literally detaining lawful permanent residents and even some U.S. citizens? And it gets worse. It's not just those masked ICE agents. There are many FBI agents who are being called away from their duties to investigate terrorism, violent gangs, child trafficking, and other crimes in order to help ICE arrest and detain immigrants with legal asylum claims, nonviolent. That makes our homeland less safe, not more safe. So we should hear from FBI Director Kash Patel about how many of his criminal investigators are being taken away from their criminal investigatory jobs, keeping Americans safe in order to help round up non-criminal immigrants trying to immigrate the right way. Some of these detainees are being held in Bureau of Prisons detention centers that are unfit for convicted criminals to stay in. We should hear from Pam Bondi about how much of the department's resources are being used to detain these nonviolent, non-criminal immigration detainees. And while they're here, we can ask them about a very pressing question. What's going on with the Epstein files? Donald Trump promised to release them. Pam Bondi said she had the files on her desk and that she was going to release them in the name of transparency. Kash Patel has spent years railing against the FBI to release the files. Many of my Republican colleagues were banging on the table to release the Epstein files. But now, all of a sudden, after a months-long review, Bondi and Patel say nothing to see here, no evidence that any American would want to see about accomplices, co-conspirators, or other people involved. Yesterday, the Republicans voted against releasing the files. So what's changed? Well, we all know Donald Trump has had a relationship with Jeffrey Epstein. He flew on his plane, he hung out at parties, spoke highly of him. And now there are many people saying that Donald Trump is included in the Epstein files. In fact, there are reporters who say that there are videos of him with topless women. Elon Musk even confirmed that Trump is blocking the release of these files because he's in them. Pam Bondi says there's nothing there, but Donald Trump even acknowledges that there is evidence there. It's just not credible. It's made up. This is a Truth Social post from 9:43 this morning. It is an admission that Donald Trump is in the Epstein files, and the American people deserve to know whether he is or not.
Mr. Garbarino is
Mr. Chairman, I would,
recognized for 5
pursuant to
minutes for
Clause
question.
2K6 of Rule
Gentleman
11.
is not recognized. Your time has expired.
I have a motion,
Mr. Garbarino
Mr. Chairman.
is recognized for questioning.
Mr. Chairman, I have a motion.
Thank you, Mr.
The gentleman has a motion.
Pursuant to Clause 2K6 of Rule 11, I move that the committee subpoena Pam Bondi, Attorney General of the United States, and Kash Patel, the Director of the Federal Bureau of Investigation.
Mr. Chairman, motion to table.
Gentleman has a motion.
Motion to table.
Motion to table is privileged and non-debatable. We shall ask all those in favor of the motion to table, say aye.
Aye.
Aye. All those opposed?
No.
In the opinion of the chair, the ayes have it, and the motion to table is agreed to.
Could I have a recorded vote, please?
Recorded vote is requested. The clerk shall call the roll.
Mr. Green of Tennessee. Mr. McCall. Mr. Higgins.
Aye.
Mr. Higgins votes aye. Mr. Jimenez. Mr. Jimenez votes aye. Mr. Pfluger. Mr. Pfluger votes aye. Mr. Garbarino. Mr. Garbarino votes aye. Ms. Green. Mr. Gonzalez. Mr. Gonzalez votes aye. Mr. Luttrell. Mr. Strong. Mr. Strong votes aye. Mr. Burkeen.
Aye.
Mr. Burkeen votes aye. Mr. Crane. Mr. Crane votes aye. Mr. Ogles. Mr. Ogles votes aye. Mrs. Biggs. Mr. Evans.
Aye.
Mr. Evans votes aye. Mr. McKenzie. Mr. Knott.
Aye.
Mr. Knott votes aye. Ranking Member Thompson. Ranking Member Thompson votes no. Mr. Swalwell. Mr. Swalwell votes no. Mr. Correa. Mr. Tanadar. Mr. Tanadar votes no. Mr. Magaziner. Mr. Goldman.
No.
Mr. Goldman votes no. Mrs. Ramirez.
No.
Mrs. Ramirez votes no. Mr. Kennedy.
No.
Mr. Kennedy votes no. Mrs. McIver.
No.
Mrs. McIver votes no. Ms. Johnson. No. Ms. Johnson votes no. Mr. Hernandez. No. Mr. Hernandez votes no. Ms. Poe. Ms. Poe votes no. Mr. Carter. No. Mr. Carter votes no. Mr. Green of Texas. Mr. Green of Texas votes no.
Am I recorded?
Mr. Correa is not recorded.
Vote no.
Mr. Correa votes no. Chairman Guest is not recorded. Chairman Guest votes aye.
Is any other member not recorded?
Mrs. Biggs votes aye.
As a gentleman.
Mr. Chairman, what are we waiting for?
I'm sorry, sir.
What are we waiting for?
We're waiting for all members to complete voting, sir.
We have all members who've completed votes, Mr. Chairman.
Call the question.
I'm sorry, sir.
We'd like to call the question and have the vote tallied. All members who are present have voted.
Your request is heard and denied. We're waiting for members to return to the chamber to vote.
Mr. Chairman.
Yes, Mr. Ranking Member.
We went through this once, but that's not in the rule.
It's kind of you to have that opinion, Mr. Ranking Member, but I'm the chairman, and we're going to wait till members return for the vote. You guys are pushing a button on these procedural votes. It's not on the agenda. It was not discussed prior to this hearing, and we're going to give all members on both sides ample time to return to the chamber and cast their vote. It's the end of that debate.
Mr. Chairman, for the record,
Perhaps it's not.
the committee didn't even give notice of this hearing. So are you talking about engaging?
I'm quite certain that the committee is within the parameters of the rules of the House and the committee. Mr. Ranking Member, you've been on the committee longer than most of us have been.
That's why I'm trying to
an
explain the
adult.
rules to you.
So I'm pretty sure you know the rules. We're following the rules.
Which rule are you following, Mr. Chairman?
You're the attorney, sir. You can look up the rules. I can tell you that I have high confidence that this committee, the staff of this committee, is following every rule, and the parameters shall be continued. We will wait for members to return to the chambers. This happens all the time. This is not new. This happens in every committee. When procedural votes are called, members have excused themselves after their questioning to handle our business. They have to return to the chamber. We'll allow that for the Democrats. We'll allow it for the Republicans. That's fair.
Mr. Chairman, we've never asked to wait on a vote.
Well,
We've
did
never
anyone tell you to ask, Mr. Ranking
No,
Member? Because
it is not
that's
the
generally
rules of the
how you
committee.
roll.
It's not the rules of the committee.
Okay, well, you're welcome to have that opinion, but I state again that the committee is operating within the parameters of the rules of the House and the committee. I have the gavel.
Parliamentary inquiry, Mr. Chairman.
I have the gavel, and I have the right to keep the vote open until members have returned from across campus to cast an important vote.
Mr. Chairman.
This is not new. It's historically accurate and traditional in Congress.
That's not true, Mr. Chairman. It's never done in this committee, and other committees have specific rules that allow for the chairman to do this. This committee does not have that rule. We are simply asking if you are doing this pursuant to the rules of the House or the committee, that you simply point us to the rule that allows you to do this, because if you are now ruling as chairman without the authority of the rules, we have a whole different issue.
Mr. Chairman, point of order.
Point of order, the
This
gentleman.
committee existed
Mr.
before the
Garber.
gentleman from New York was a member of Congress. I was in the minority back here in 2021, and some of my colleagues did. And the ranking member, who was chairman at that time, repeatedly held votes open when they were not, for members to return here to vote. Not because they
Gentleman
were for one way or another, but for members to get back on procedural motions. I've experienced it when I was in the member minority. Members were allowed ample time to return from unscheduled votes in this committee. Thank you.
The gentleman yields, and the gentleman is correct.
Gentleman from New York.
Is
Since
the
you
ranking
ref-
member asking to be
Yes.
recognized?
Mr. Cabaret, that's not true. When did that happen?
The ranking
did that
member is
happen?
not recognized. Does Ms. McIver wish to be recognized?
No, I'm still talking.
You haven't been recognized.
You recognized me.
Would you like? I did not.
You did.
You want me to recognize you now? You recognize now?
Obviously, I was talking to you already, Mr. Garbarino, because I had been recognized.
Yeah.
But that's not true. That is factually not true what you said.
That is, I don't recall the date, but I recall it happening. I recall votes being held open. So because whether there were other votes or other committees, there was procedural motions. There were also markups where votes were held open or sometimes
You're
delayed.
playing my time. Look, all this is just delaying till somebody get here. And Mr. Chairman, the rules are the rules. And for you to try to make them up as you go, that's not how you do it.
You gentlemen yield.
How am I recorded?
Mr. Magaziner has not been recorded.
I asked to be recorded as a no.
Mr. Magaziner votes no.
Mr. Chairman, while we wait, can I introduce a UC request?
Gentleman has a unanimous consent request. You recognize?
I would move to introduce a Truth Social post from Donald Trump from 9:43 a.m. Railing against.
Mr. Chairman, we're in the middle of a vote. I don't think you can entertain a UC request.
I'm advised, that although I'm quite generous with recognizing my colleagues across the aisle here, it's contrary specifically to the rules for you to introduce unanimous consent. Will the gentleman let us close this vote out? We're happy to recognize.
Of course, I'm happy to
Thank you, sir.
reintroduce.
Mr. Chairman?
Trying to be polite.
Mr. Chairman? Given that there seem to be some attendance issues, at least on the Republican side, I move that the committee do now adjourn.
There's an open vote right now. You're welcome to make a motion to adjourn after we close this
Mr. Chairman,
vote.
point of order. A motion to adjourn is the highest privilege, so it would
I'm not doing an
supersede-
open vote.
It would supersede.
Motion
The
to
open
adjourn, if you continue with your motion and enter your motion after we've closed this vote, then the chair will entertain that.
But parliamentary
Right
inquiry,
now,
can I make a?
this vote is open, is going to remain open until
Chairman, can I ask a
members
question?
have been allowed to return.
Parliamentary inquiry, my understanding is that a motion to adjourn is the highest privilege and has to be acted on even if there is another open vote. Particularly a vote that's not being
Agreed.
properly closed.
With concurrence, which is reflective of my understanding, I respect Mr. Magaziner's position, and it is privileged, but cannot be entertained during an open vote. And this is an open vote. So if you would like, enter a motion to adjourn, good sir, we will certainly entertain that once we've closed this vote.
Mr. Chairman,
The madam is recognized.
request a tally.
Gentleman is recognized.
Request a tally of the vote as it stands at the moment.
Yeah, the chair will request a tally at conclusion of the vote, when we close the vote.
Green from Texas, Mr. Chairman. May I be recognized?
Of course, my friend from Texas is recognized.
Thank you, my friend. Is it in order to make a motion to close the vote?
I don't believe that a motion to close the vote is in order or required. The chair is keeping the vote open until members from either side of the aisle return to the chamber for this unscheduled procedural vote.
And may I consider this a ruling of the chair?
You can't challenge the ruling of the chair on a motion that's not recognized during an open vote. So if you continue if you would like to submit a motion to adjourn, I would suggest you follow the rules there as well, but you'll have to wait until this vote is closed, good sir.
What I would like to do is as we have done with other motions, is appeal the ruling of the chair.
You're welcome to appeal the ruling of the chair if it's within the parameters of the rule, but that appeal will not be entertained during an open vote.
Mr. Chairman, you have made a decision by
There you
keeping the
go.
vote open. That is, in effect, a ruling. And Mr. Green is appealing that decision you've made.
Yeah, we're not going to entertain a motion or an appeal while the vote is open, Mr. Ranking Member. You know that.
Well, I know it, but it's not the rules.
We've always, and ladies and gentlemen, I understand your position. Understand you making a stance in the Homeland Security Committee.
We're just making a
This
stance
is
for you to follow the rules.
historically and traditionally, this committee and every committee I've served on has kept votes open when you have an unscheduled procedural vote to allow members to return to the chamber and cast a vote.
Mr. Chairman?
This happens if we're in the majority or you're in the majority. It's ideologically, appropriate from either perspective to allow your members to return to the chamber. And it's certainly the historical and traditional means by which we deal with unscheduled procedural votes.
Mr. Chairman?
Who was that, please? Mr. Brashean.
Yeah, point of order, or parliamentary inquiry, I would put it to you, but I would put it to the Democrat opposition also, is I would love for someone to point out where the rules say that you, as chairman of a committee, do not have the discretion over this matter. The accusation that the rules are being violated, but yet where is it in the rules that does not give the chairman the allowance or the discretion to make this decision?
Mr. Brashean yields. Mr. Clerk, how is Mr. McKenzie recorded?
Mr. McKenzie has not yet been recorded.
Aye.
Mr. McKenzie votes aye.
Wait on one more.
Mr. Mr. McCall has not been recorded. Mr. McCall votes aye.
Clerk will record a tally.
Mr. Chairman, on that vote, there were 15 ayes and 14 noes.
The motion to table has succeeded, and the chair recognizes Mr. Magaziner for questioning. You have a motion, I'm sorry. Mr. Magaziner, you have a motion?
No, I'll proceed with
The gentleman withdraws his intention. Mr. Garbarino?
Thank you, Mr. Chairman. Thank you for the witnesses for being here. I'm sorry that you're experiencing this.
Someone yields back. The gentleman from New York is recognized. Mr. Goldman.
Mr. Patel, does Donald Trump appear anywhere in the Epstein files?
I'm sorry, could you say that again?
It's not a complicated question. Does Donald Trump appear anywhere in the Epstein files?
I didn't say it was a complicated question, I just didn't hear you, so my apologies. We have released where President Trump's name's in the Epstein files and everybody else, and all credible information that we are legally allowed to release has been released.
All right, so let's go through that. You're referring to court orders that prohibit you from releasing grand jury testimony under Rule 6E. Is that what you're referring to when you say as the law allows?
That's a piece of it.
Really? What other evidence do those three court orders you cited prohibit from being released?
information that was collected pursuant to those search warrants that were limited
Wrong.
in fashion.
Wrong. That's not what the court order says, and that's not under 6E.
And you're talking, and I said that's 6E, and I said there was others, and I'm answering that. There are sealed court order documents. There are protective orders. From
They
the
are
court.
unsealed as part of discovery given to Ghislaine Maxwell. They are no longer sealed.
That's just not true. We can argue about it all you want.
Okay,
or we
well,
can go
you
to court.
agree that there are, so your testimony here is that the reason why you are not releasing all of the videos that you have acknowledged, there are so many, and that the FBI spent thousands of hours of reviewing, the photographs, all of the photographs that you have. You're saying that you're not releasing those because there's a court order requiring them to be sealed? Is that your testimony?
Never said that about the videos. On the totality of the videos, of the thousands of images that were seized pursuant to the search warrants executed at the time, the overwhelming majority of that video is pornographic material that was downloaded from the internet and child sexual abuse material. We will never release that.
Well, as you should not release the victims. But if there are videos that relate to others who Epstein trafficked to, such as maybe Prince Andrew, or photographs, that you have total control to release.
Yes, and if it exists.
And so why haven't you released it?
Why are you supposing that that is a fact when in fact it is false? Are you saying that
You're saying that none of the videos relate to anything relevant to the Jeffrey Epstein trafficking ring?
Every single video that we have collected pursuant to the prior search warrants has been examined for the last 10 years. And every single video has been utilized for whatever prosecutions were able to be legally brought.
I'm not asking about prosecutions. I'm asking about why you aren't releasing the full Epstein files, including the names of people who were involved in the sex ring that you promised to do before you became FBI director.
I just told you, I'm not going to release downloaded porn of
I'm
children
not asking
on the
about
internet.
that. Fine. I'm asking about all the other files.
What other videos? Tell me. Tell me.
That's what I'm asking.
Tell me.
You're saying there are no videos that would be relevant to anyone else involved in the Jeffrey Epstein sex ring.
Pursuant to Mr. Acosta's collection of information based on the search warrants. That's all we have in our
I
possession.
understand. And I'm asking you, that stuff.
That's all we got.
I'm not asking all you got. I'm asking you, in that stuff, there's nothing that's related to to any other sex traffic, any other people engaged with Epstein in underage sex.
That's correct. To my knowledge, no.
Okay. Let's talk about the witness interviews. 302s of witness interviews. Those are not subject to the court order. Those are not subject to any fictional sealed order for a search warrant. Why aren't you releasing those with the redacted names of the victims?
We are releasing as much as legally allowed. That's why we went back to the
How is
courts.
how is that not legally allowed?
Sir, do you know how court orders work? Do you know how protective orders
Actually,
work? Do you know how
Mr.
sealing
Patel,
orders
I was
work?
a real prosecutor for 10 years. I know exactly how
so I was a
court
fake one?
orders. And I want to understand what the court order prevents you from releasing witness statements that the FBI took.
You should know that as a real prosecutor, when the court hand downs a protective order and a motion to seal, the material is sealed unless
So
that
your
judge
testimony
waives
here
it.
is that all of those witness statements are under a court order, a protective order.
We are providing everything we can legally provide.
No, that's not my
Congress has
question.
sent us a
My
subpoena.
question is, why are those witness statements that are not grand jury testimony, that if they were under a protective order are no longer under a protective order, why are they not being released?
How are they not under a protective
Why
order?
are you not going to the court like you did for the grand jury testimony to unseal those records?
The DOJ did go to the court.
No, not on those records. Why aren't you going? You just went on grand jury.
Time of the gentleman has expired.
You are hiding the Epstein files, Mr.
Time of the
Patel.
gentleman has expired.
You are part of the cover-up.
Can I respond?
Sure can.
Any allegations that I'm a part of a cover-up to protect child sexual trafficking and victims of human trafficking and sexual crimes is patently and categorically false in the work of my
So I hope you will talk to them when they
Gentlemen's
have
time has
requested
expired.
to speak with you. Because
Gentlemen's
the
time has
victims
expired.
have
Gentleman
requested
yields
and you are
back.
not responding to them.
Director, yes or no?
Thank you very much, Governor Hochul, and you said it so right. This is not just an attack on Tish James, but it is. This is not just an attack on New York, and it is. This is an attack on every single one of us here tonight and around this country. Because Donald Trump directed his Department of Justice to file this baseless, bogus, meritless, bullshit indictment. And you don't have to guess that because he tweeted it. So we know exactly where this is coming from. It is not an allegation. It is not in dispute. The actual prosecutor looking at this case said, no, there's not enough evidence to charge it. Donald Trump fired him. He then put in his own ambulance-chasing lawyer to be a prosecutor, who then found nobody else who could go to the grand jury. That's how bad this case is. But it doesn't matter in Donald Trump's world, because in Donald Trump's world, you can demolish the East Wing and take $300 million from your friends and build a ballroom. You can decide that if someone invests enough money in your crypto company, you'll give them a pardon. You can decide that I'm going to use this government to get my enemies. Now, Tish James has stood up for New York for decades, and as Attorney General for 7 years. And she has gone in to courtrooms all around this state, standing up for everyone here and all of us around the state. And tomorrow she is going into a courtroom, but she's once again standing up for us. She is standing up for New Yorkers, because if Tish James bows, if Tish James bends with this political prosecution, then we're all at risk. We're all in jeopardy of having Donald Trump come after us. There is no Department of Justice. It just becomes the Department of Revenge. And because we have our fearless leader, Tish James, we know that she's going to stand up for all of us again. And we are lucky in some respects that he came after her, because that was a bad move. That is the wrong person. And so we are all here tonight proudly standing up and saying, we stand with Tish James. And Mr. President, you better get your hands off Tish James. Thank you. Now I am honored to be able to introduce my neighbor to the north, one of the best leaders that this city has, Congressman Adriano Espaillat.
All right. Good evening.